Good evening, everybody. This is Omar Serrano with the Tilted Lawyer podcast, joined by the legendary Cassidy O'Connell, who
Hey,
has
everybody.
found her way onto the docket in this ripping case, this compelling case out of New York, out of the Second Circuit, that has gripped the hearts and minds of well, I don't know whose hearts and minds it's gripped, but it's a popular celebrity case that we've been following. I took a 2-month or maybe a month and a half vacation from this case because of other things that I was doing professionally. And but now I'm back. And in the time that I was away, there was a whole second amended complaint that was filed that I didn't find out about until there was this motion to dismiss. It's like, oh, they amended their complaint. Well, look at that. And so
I didn't even realize you totally missed that. I knew you were gone for a bit, but I didn't realize you totally missed that too.
Yeah, no, when I say I was not following this case, I was not following it. I wasn't watching Lauren's streams. I would catch them, but I was just focused on other things. And so like the machinations of everything going on with this case, I've been totally out of the loop. But I'm back in.
You kind of need a break from it. I took a couple week break this month, and it did me a world of good.
By the way, I like to point out, I don't know what the name of this wine is, but it sat in my car one day and like it was 100 degrees.
Is it vinegar?
No, it's not vinegar. I asked ChatGPT, hey, so did I just ruin like 12 bottles of wine? Because I accidentally had like a case of wine delivered to my office because I get like this subscription thing.
Yeah.
And I just left it there in my car. And ChatGPT is like, yeah, the wine's ruined. It's going to taste stewed. And I was like, what does that even mean, stewed? And I'm tasting it. And honestly, I can't tell the difference. I could not tell you. I could not tell you. It's not bad. I give my wife the other half. She has the other half. I just said, hey, just so you know, if this tastes weird, it's because ChatGPT said it was stewed.
Stewed. I never heard of stewed for wine.
Yeah.
But I've had it like end up tasting like vinegar.
Oh, I've done that when I try to open a for my 40th. There was my mom had like a bottle of 1990 champagne or something that she kept like in her garage, like not properly stored at all.
Right.
Yeah. So when we cracked it open, there was no fizz, and yeah, it was vinegar. It was bad.
Oh,
really disgusting. I don't know if champagne was the best choice, but So anyway, here's my prediction for this case. The title seems to suggest that Blake Lively's complaint is in a lot of trouble. And it is, but it's not going to be a complete dismissal. Number one, they didn't even attack all of the 15 counts that are in the Second Amendment complaint. But it's going to get whittled down considerably. And most interesting to me was the extraterritorial arguments that they used in opposition to the 47.1 claims. They used those again in this motion to dismiss.
Yeah, there was quite a bit that was word for word and a lot of the same case law.
Yeah, and it applies because it's right. Look, if state statutes do not write in an extraterritorial sentence or leave some indication that this relief will be available for conduct that occurs outside of the state, then it doesn't exist. And the law is pretty clear on that. There are 0 cases to the contrary. So if Judge Lyman agrees with that, that kind of erases 47.1. My other thought when reading this is some of the FEHA-related remedies that Lively could have asserted, specifically with it ends with us not exhausting administratively all of their ability to pursue administrative remedies or whatever. That one, they had like 300 days to remedy that. So they could have raised this like in a demurrer. They could have raised it in 12b6. And everybody's wondering, well, why didn't they do that? Well, maybe some of the reason is because they were waiting for these 300 days to expire, because then it's just statutory. And now all the FEHA related stuff related, well, I guess to at least it ends with us, is out automatically, and they don't have to really argue about it. And the effect of the effect of this motion for judgment on the pleadings It's basically the same thing. We're doing the same thing that we thought that Lively was trying to do months ago. We're just doing it after her ability to fix some of the things has expired.
Which is brilliant. And
that's what I thought.
Brian Friedman made a statement way back in the motion to dismiss time frame, and he said, I'm not filing a motion to dismiss because I'm not telling them how to fix their failing pleadings. And now we see what he was talking about. And had he done it then, it might not have been past the 300 days. I didn't count the days, but I thought
it would have been 300 days, I guess, from
I didn't
December.
do the math.
I don't know. But yeah, I have not done the math.
Also, yeah, it's really, really close then.
And I will not do the math. I'm just going to assume that they're right when they say it's the 300 days is expired.
Yeah.
I think they outlined it in their motion, which we can go through. But just as, I wrote down, you made a whole chart, which is what I was going to do, but then I forgot to do that.
We'll just share it. And then what I wanted to do with the last column is which ones you think Wayfair can effectively blot out. And then at the end,
I'll tell you this.
I'll put up a new chart with the answers.
For the too long didn't read version, I'll just tell you exactly what I think. Count 1 is going to stay in because it wasn't challenged.
Yeah.
Well,
they said they want that day in court. They want to prove their innocence for that claim.
Right.
So I didn't think they would bring that one up.
They didn't. They just count 2 is going to stay in. It's a Title VII claim for retaliation, but not as to it ends with us. That is out statutorily. That's gone.
Now, what about the point that without the adverse employment action, you can't have retaliation? How will they overcome that? That's likely going to stay in
because it's debatable. It's one of those claims that the statute says that it should be interpreted a certain way, but Lively has an argument that it might not be interpreted that way. And so therefore for the trier of fact, right?
Okay.
Yeah. So it's count 2. It's going to get dismissed as to it ends with us, but it's going to remain against everybody else. But she's going to have a tougher time pleading it against the other parties. And we can talk about that later. Counts 8 and 9 are going to stay in because they were not requested to be dismissed.
Those are 8 and 9. Yeah, they didn't say anything about those.
Yeah, because it's going to stay in.
Nothing. Was there no argument they could have made for those?
No, not really.
Yeah,
not really. It was I believe those were like the nudity rider stuff, wasn't it? It was the contractual stuff, like the contractual stuff.
Yeah.
Counts 8 and 9. The contracts, the nudity riders, those were those counts.
So they probably just weren't ready to even bring that up yet.
Right. The defamation claims related to counts 12 and 14 are likely going to stay in because she has arguments that she can make. The conspiracy count is likely going to stay in, and that's the one that you said was kind of over your
that
head.
one I couldn't understand. There was just too many moving parts.
Well, they were just like, so here was their argument. Basically, when whatever she alleges happened occurred, she was not an employee of anybody related to the Wayfair parties. Mm-hmm. And so therefore they had no ability to commit conspiracy because she was completely uninvolved. Plus there was a time gap of like 15 months between one thing that led to the conspiracy. So therefore the passage of time made it, based on the case law, unlikely that anybody would rule in her favor as to conspiracy. But there's arguments that she can make based on what she pled in the SAC, basically a string timeline of events that led to perhaps this was like this chain of events that took 15 months to play out, but it began, and as unlikely as it is, she can make that argument and a jury could decide. So therefore, it's a really weak case. And by the way, everything that I'm saying is staying in. I don't think she's going to win on these issues, and I think she knows
just
that
it won't be ruled out this simply, it needs a trier effect.
Right.
What you're
Right.
saying?
So, and I'm kind of using the same analysis that I did on the 12B6 as to Baldoni's complaint, which is essentially, unless there's a procedural reason to get it out, then it should stay in because of issues related to trier effect. So by that standard, and Judge Lyman disagreed with me, he tossed the whole thing basically, but for a couple of things.
Disagreed with everybody.
I know. And the way that he handled that, and I had Rachel Juarez, and we were like, we don't understand why he's writing his opinion into a 12B6 motion. It seems improper. If he judges it by that, if he does the same thing to this complaint, then he might very well just kick out count 2. He might kick out counts 12 and 14. He might kick out 12, 15. If he rules on this the same way he did with Baldoni's motion, then I could see a world where only counts 1 and 8 and 9 survive. And that's the hostile work environment thing under Title VII and the contract writer stuff.
Okay. So let me see. I'm getting ready to type in. So you think ultimately the 1, 8, and 9 is all that will stay?
No.
Or are you still saying, okay, so 2 you're saying will probably stay in. The
Let's do it this
FIHA.
way. Here's what's definitely out. What's definitely out is counts 3 through 7.
Okay, 3 through 7.
Because extraterritorial, right?
Okay.
Because there is no carving out for conduct outside of the state. And if it doesn't exist, then it's out. That's what the case law says. And if that reasoning holds up, then 47.1 and its application in this case is dead.
Good riddance.
Right. Count 13, similarly, requesting relief under 51.9 is likely out because it's
13?
extraterritorial. Yeah. There's a mismatch as to conduct that occurred versus workplace facts in her Second Amendment complaint. It's not going to survive.
Now, the false light, New York does not recognize, even if they're applying another state's law. So you think 12 is out too?
12 and 14, because false light is not recognized.
Yeah.
And then the Title VII and FIHA claims against It Ends With Us is gone for failure to exhaust administrative remedies. So those counts are definitely out. So 3 through 7, 13, 12 and 14 should be gone just procedurally. Count 2 will.
Oh my goodness, what just happened to my?
Count 2 will survive, but not against It Ends With Us. Counts 8 and 9, I don't think anybody's challenged. They didn't challenge that in the motion, and there's no reason to really. The defamation claims in counts 12, 14 should probably survive. The conspiracy count should survive. As weak of a cause of action as it is, it should still survive the pleadings. And count 1 wasn't challenged, so that's definitely
staying. Yeah.
Yeah. So that's my official prediction. I don't know where that lands on the chart, but that's where I'm at.
Okay. Sorry, my document went nuts while I was typing, so I was trying to fix it while you were talking, so I might have missed some.
Oh, well, we can always go through it again.
Let me put this up and you tell me if I got some of them wrong, because it just went nuts. And then okay, so 2 is the one that it stays in except for It Ends With Us movie.
Yeah, but it should stand as it relates to everybody else. Basically, everything that you have a FIHA claim or law under FIHA, that's out. 3, 4, 6, and 7 gone. Retaliation, the Fifth Amendment, I think I said that that's gone. I'm pretty sure that that's gone.
All right, let me see if I can save this as a picture straight from here. No, just a PDF. Oh, sorry.
No, you're good. You're good.
You can hear my computer going, no.
Yeah. But while you're doing that, I will go through some of this document. I'm not going to go through it word for word. I'm just going to, highlight some of the stuff. So we take your chart off, and I'm going to put on the complaint And just let me see if I could do something about how I have this situated here. Could you see that okay?
Oh wait, now I can't. I couldn't a second ago, and now it's half. Yeah, there.
All
That's
right, there
good.
we go. So yeah, the important parts, if I highlighted in green, it's because there's like a precedent, there's controlling law there. So they start off with the introduction. She fails to plead stuff, cognizable claims under FEHA, Title VII, whatever. This was a big one. FEHA does not have extraterritorial application, and thus plaintiff's FEHA claims, third, fourth, sixth, seventh, or sixth and seventh causes of action should be dismissed with prejudice, and I agreed. Plaintiff's claims for violation of other California statutes, including California Labor Code 1102 and 51.9, fail for the same reason. She fails to allege an adverse employment action, which is a requisite for retaliation claims. That's the one where that's true, but she can make arguments. And for those reasons, I decided they should, on this motion, remain. Like if she can make a viable argument, then you should leave it in. They say that Lively fails to plead a causal link between her complaints of harassment and the alleged smear campaign. And yeah, there's arguments to state that, but there's also arguments that she can make. Therefore, under the way that I would evaluate this, those causes of action should stay in.
And be left to effect.
Yeah.
She did do a good job of finding multiple cases that were even not as far apart as Blake's, and they were not allowed. So in the end, I don't think it will stand, but I can see what you're saying about it requiring a trier effect.
Yeah, it's just like, look, I'm innocent because aliens came down and controlled my movements. Like, if you could show a modicum of evidence to suggest that you can make an argument, then it should stay in. I mean, obviously that's ridiculous, but like, what if there was evidence to say that like the window was melted and there's nothing on earth that can melt glass, without making a racket? And, you can tell this compelling story that a jury could decide if you're full of shit or not. And it should stand. And if it's pled in the pleadings, then you should be able to make that argument is the point, Obviously that's a ridiculous example, but that's kind of the standard. Like, is there a counter argument to this? And there is. Even if you don't agree with it, there is.
So how long does Blake have to make a counter argument to this?
Well, she's going to write her opposition. There's not anything. I think she has 30 days.
30 days?
Yeah, don't quote me on that.
And then they get one more shot, and then then it goes to the judge. Is that correct? Is that how it goes?
I mean, that's how it can go. It could also just be like, look, here's their motion. You got in your opposition. I'm going to make a ruling.
Okay.
But it can go that they get to go, she gets to respond, and then they get a response to the response. And then, if I was a judge, I'd just write your thing. You write the opposition. I don't need rebuttals. We could do that in an argument. Or I could just rule on the pleadings. If they don't have a good response to the statutory stuff, then that's just automatically out. And Judge Lyman has shown a willingness to get rid of stuff where the law makes him do that. And so
and then it's less work for him later too to have to make rulings on those things. If he can just say,
wants to, for sure, nobody wants to have a trial on 15 causes of action. That's ridiculous. And
and then have to take in other states' laws and stuff.
Yeah,
he's probably thrilled.
If he could get out of having a rule on 47.1, I feel like he's going to do it. I feel like he's going to say, extraterritorial. The hell with this. I'm not dealing with it.
Exactly. So do you agree with what most people are saying, that he will not want to be the one to rule first impression on that law?
If I was a judge, I wouldn't want to be the one.
Yeah.
On this case, I would feel like extraterritorial deficiencies make all the sense in the world to take this out of my hands. Why should the Second Circuit set precedent on a California statute?
State law.
That makes no sense. Yeah. California did not carve that out for me, so I'm not going to deal with it. Sure, I could see him doing that. Now, on the other hand, if there was some language in the statute that allowed for it, then I guess he would have to. But yeah, there was and in one of these content creator subpoenas, didn't he specifically rule that, yeah, I don't have jurisdiction over this. You got to go to Vegas. Wasn't that Paris Hilton's subpoena?
Yeah. Which makes me so mad. I still am mad because there were at least 5 of us that after she withdrew our subpoenas, the way she did it, she lied. She made it sound like we had met and conferred with her, and we did not. None of us. And then she said something like, for now, like it sounded like she could come back at any point. So we were like, and then we knew that she had subpoenaed Popcorn Planet from 2 different platforms, and then attempted a third, but the third was some kind of copycat on TikTok. It wasn't actually him. But we're like, she's going to come at us from somewhere else that we don't see coming.
Yeah,
and
I wouldn't put it past her.
We wanted the protective order, and then I wanted the judge to rule on it, to say this subpoena is no good. And to me, like, Perez proves that that's true, because you cannot write a subpoena for outside 100 miles. You lose jurisdiction at that point.
Right.
Google and all them, they're in California. They're on the opposite coast. So this was well beyond New York's jurisdiction to have been able to sign a subpoena.
To that note, I don't even think it would have been that difficult to come up with a protective order that would have allowed them to preserve their discovery rights.
We asked for one, and he ignored all of them. He never addressed any of them. And then Ezra, because she knew that the law was on our side, she didn't like put out a motion, but in a footnote, she's like the queen of. Someone said she has a footnote fetish, and I thought that was hilarious.
Maybe she did.
She put a little footnote saying, asking him to disregard our filings or something like that. And then he didn't respond to her. He didn't respond to us. They're all just sitting there, and I'm still mad about that.
Yeah, I mean, I could see why. I mean, you got pretty heated. I remember seeing some of your streams, like reading your submissions on the docket. I mean, and I completely understand why. And I would not want to be, as a content creator, pulled into this bullshit. Yeah. I thought that it was curious that the lawyers that were covering, I think there was a couple that were, I think Leanne, didn't Leanne Newton get a subpoena?
Yeah.
I can't remember if she did or not.
Yeah,
but she's did. Like out of, she's overseas though.
Yeah, she's in England.
Yeah, I don't think that any
Ashley's in Canada.
Yeah, I thought that was odd. I really thought it was odd that they didn't subpoena any American
attorneys,
lawyers. Yeah, that were covering this case. But you know, that's a whole separate ball of worms, or can of worms, that I do not want to get into with this. But skimming over some of this, they talked about the 17-point list, and they're talking about some of the facts that we don't need to rehash here. But this is important. So the standard for judgment on the pleadings. This is why I say that the counts that are going to stay in are going to stay in. Judgment on the pleadings is appropriate where all reasonable inferences drawn in favor of the non-moving party has failed to allege facts that would give rise to a plausible claim or defense, which is why I stated that, the conspiracy stuff, far-fetched, but they can still reasonably come up with something compelling for a jury to consider. And so therefore, and then there's this case Twombly. This is the one that they all make us read in law school. I hated this case. The Iqbal and Twombly. Yeah. I hated those cases. I hated civil procedure in general, and I hated these cases because they were so prominent on my civil procedure final. I hate everything about these cases. Either way, this is what it says. A complaint must offer more than labels and conclusions, of formulaic recitation of the elements of a cause of action, or naked assertions devoid of further factual enhancement in order to survive dismissal. The plausibility requirement calls for enough fact to raise a reasonable expectation that discovery will reveal evidence supporting the claim. And then, they say more stuff. I'm already boring myself.
So that's the point that you feel keep them in.
They just kind of have something to argue, man.
Slightest.
Yeah, it's like, I don't know if you've ever
Not
happened
that
to.
he gave Wayfarer that opportunity, but
No, I disagree with about the Baldoni ruling completely because of Twombly.
because of that. Yep.
Iqbal, yeah. For that very reason. And so therefore, I'm not going to just change my understanding of law just because I thought Lyman got it wrong. Matter of fact, if he rules the same way with Baldoni, then it seems to me that there's only going to be 3 counts that survive.
Yep.
And that would be count the ones that weren't challenged, basically. You know?
Yeah.
I forgot what I said, but count 1, count 8 and 9.
Was it 1, 5, and 8? Or is it 1, 8, and 9?
Yeah, the contract stuff.
The breach of
And
contract and the SH, because they didn't contest any of those.
right. Under Lyman's last ruling on this kind of a motion, I can see where he would, under his own analysis, get rid of the other stuff, get rid of the conspiracy, get rid of the, all the other counts. But for 1, 8, and 9 that weren't challenged, well, if you want to bring up the contract stuff, then bring it. And nobody asked for dismissal of count 1 so that could stay in 2. That's what he did to Justin. And then he said, if you want to amend it on the contract stuff, because I don't know what contracts we're talking about. That's basically what he said. And then Baldoni's like, yeah, I'm not doing that. Screw it. And I feel like they probably had this discussion about 47.1 that they have this extraterritorial argument that they're going to make around this time. We're in September now. That is going to get rid of 47.1 potentially, and a lot of these other FEHA claims and all that kind of stuff. So,
yeah, because there was in one of the case law that she quoted, there was a woman who actually was Californian, but she worked in Nevada. And so even her being from California herself, because her employment was in Nevada, it didn't count. She wasn't able to claim it. So how much more so is Blake's claim going to fail?
Because California courts, they could give a shit about your residency. They care about the where the conduct took place.
Yeah.
And this took place in New York and New Jersey. It's not enough to say, oh, but there was headquarters in California. Nobody gives a shit. Nobody was doing anything in California. So it shouldn't apply, which is fair,
Right.
All right. So the threshold question is, this is about the FEHA stuff. The threshold question is whether FEHA or the other cited California statutes have extraterritorial application, whereas here, the plaintiff is not a California resident and the discriminatory conduct did not occur in California. FEHA does not protect non-California residents such as Lively, where the allegedly discriminatory conduct occurs outside of California. California recognizes a presumption that the California legislature did not intend a statute to be operative with respect to occurrences outside the state, unless such intention is clearly expressed or reasonably to be inferred from the language of the act or from its purpose, subject matter, or history. That's Sullivan. So these are bad cases that Lively's not going to be overcome. There's more. Red means bad for Lively. This is just more state law. When I was in law school, I used to do that. Like all the green was facts, like the yellow was like precedent, like red was laws. I forget. I had a code. I had like a whole system in law school in our briefcases.
That helps your memory too.
No, it really does. It helps you like find stuff really fast, especially when they call on you in law school and it's like, hey, so what was the precedent that was stated in this case from 1947? And then you just got to look for your color-coded highlighting. Anyway.
Yeah. Smart.
Yeah. Well, I got that out of a book. Like it was like one of the first things, like something for 1L students. I don't know, like preparing for law school. I forget what it was called. By the way, don't go to law school. It is not a lot of fun. This is where we get into the substantial contacts thing that I thought didn't really matter much. To determine whether there is a substantial connection, courts look to the location of where the core of the alleged wrongful conduct occurred. A plaintiff cannot merely make a formulaic conclusory blanket recitation of ratification by a non-resident defendant to establish the necessary nexus, but must have a factual nexus between the defendant's California-based activities and the alleged discriminatory conduct. In other words, we look to where the conduct occurred. And that's what all these other cases
And if you
outline.
can't link it to that, you're screwed.
Yeah. And then this green part is what they're arguing. Lively is a New York resident. The acts occurred during the first phase of production on the New Jersey set and in New York. The hostile work environment, which she alleges, the core of the alleged wrongful conduct was not in California, was in New York and New Jersey. Second Amendment complaint lacks specific averments of any participation in or ratification of the harassing conduct by Wayfair or It Ends With Us in California. There's more stuff like that. And they're making similar arguments. Plaintiffs claim for we're getting to retaliation stuff. So plaintiffs claim for retaliation under California Labor Code 1102 against Wayfair and It Ends With Us. There's no better. Courts have recognized that neither the express language of Section 1102.5 nor its legislative history indicate the California's legislature's intent to extend its application beyond California's borders. In O'Connor, for instance, the court rejects this notion that extraterritorial application of Labor Code 351 and 2802 become the California legislature because the California legislature failed to specify that either provision should be applied extraterritorially and therefore doesn't exist. I'm going to move on from that. So that's pretty clear, right? That extraterritorial stuff is a big deal.
Yeah.
Because if it gets dismissed, if it works for this motion to dismiss, then it should work for the 47.1 application.
Absolutely.
And therefore, we get rid of all of this, these 47.1 red herrings.
Mm-hmm. And the fact, I don't think he's going to want to rule as first impression for.
You know what would be hilarious, though? Like if there was so much energy expended on this 47.1 argument by myself and other lawyers, and for it to just be erased with this extraterritorial argument.
Makes me so happy.
Oh, it just.
Well, I've always said it's not going to make it. I've always said it's not going to be a part of the trial.
I don't know. At first I thought it wasn't going to be that big of a deal. And then all of a sudden I thought it was going to be a big deal. I started freaking out about it. And then, all the arguments that I made against it were constitutional arguments. Turns out that you could just get rid of it because it fails to give extraterritorial provisions to it. And so therefore it shouldn't apply. Gosh,
and
brilliant.
The thing is too, Blake is on record because after she made that 17-point list, and then somewhere, I cannot remember for the life of me where it is, but it's actually in writing that she said that after that, there was no further conduct that was troubling. So there was filming in California, but it was at the very end. And because she has already said on paper that nothing happened in that second part of filming, that completely excludes California.
100%. Yeah, no, you're absolutely right. There was no conduct in California that would have implicated 47.1 if you buy into these extraterritorial arguments. That's like the definition of Occam's razor, isn't it? Like the simplest explanation is usually the one that's correct. Conduct wasn't in California, therefore, no, man, we're not applying 47.1. Gosh, why didn't I think of that? I know. Elizabeth Harden, thank you for becoming a YouTube member. I appreciate you. Just Ricardo, these two beautiful voices are making my night. Oh, we love you, Ricardo.
He's always there, so supportive.
Always. And Aquanetta, my favorite, says, thank you, Omar and Cassidy, for the breakdown of this case. Happy to see you, Omar. Been missing you. Yeah, I've been missing being the tilted lawyer, man. Sometimes I just want to be the tilted lawyer, Sometimes I just don't want to be a lawyer. I'd rather just be the tilted lawyer on YouTube and, talk shit on the internet. And, it's so much easier than the other things that I do. All right. I'll move on with get to some of this other stuff. All right. So plaintiff's Title VII and FEHA claims against It Ends With Us fail because plaintiff does not plead that she exhausted her administrative remedies. So this all sounds like really damning, and it is, but it's only to It Ends With Us as a defendant. All of the other parties are left in.
Yeah, because she
Like,
forgot to put their name on the.
yeah, and so it's not as big of a win as you would think. It's literally just who it ends with us. And so, like, if there's people out there that are claiming, oh, she's going to get her entire complaint is getting dismissed, it isn't. It's not. It's not. It's going to get significantly whittled down. It's not a complete win. So this only applies. It doesn't apply to Justin Baldoni. It doesn't even apply to Wayfarer. It doesn't apply
But
to
how
Jen
does
Aiden.
that work with contract claims? If the contract is between her and it ends with us.
Well, this only applies to Title VII and FEHA claims. The contract claims are in counts or causes of action 8 and 9. So they're unaffected.
Okay.
Title VII is specific relief. FEHA is specific relief. And it requires, not only is there extraterritorial applications, there is strict exhaustion of administrative remedy applications that must be applied, and failure to exhaust your administrative remedies means that you lose in civil court. Like, in other words, she files her CRD complaint and then gets a right to sue letter. She needed that letter to be able to proceed with this. And she got that letter, but she just failed to list it ends with us. So therefore, she can no longer claim anything with that. Now, what does that mean with respect to, now look, there is a world that exists where the judge might say, well, she probably thought that by listing Wayfarer, the corporation, that Wayfarer was under it ends with us. And so therefore, maybe she could make that argument and maybe fix things. Maybe, or just, I could see Judge Lyman say, yeah, it ends with us is out. You're going to have to get them some other kind of a way.
Yeah. It depends on if he rules the same way he ruled against Wayfarer.
If he's consistent,
or if he keeps separate rules for her still. Let me ask you this question, and it's what I've wondered about, and I've said what I think, and I've heard a couple of other attorneys since then say the same thing. Do you think her claims would have fared better if she had filed in California and kept it in California?
No.
No?
Because she'd have the same issues.
These same things, yeah.
Now, if you're talking about a state case in California, there's jurisdictional issues with that.
Oh, okay.
None of the conduct occurred in California.
It would have had to go federal either way, right?
Yeah. If she tries to file a federal claim, like we're in the same, we're playing by federal rules. The federal rules don't disappear because she files in the Ninth Circuit versus the Second Circuit. And so I think, especially with these California statutes, they look to the conduct and where it occurs. That's where they look. Just legislatively, so that's what they do.
Even 47.1, you think that could have been killed that way too?
Yeah, I think, well, I mean, not by virtue of, it wouldn't be automatic, but they're arguing that 47.1 should not be available for conduct that occurs outside of the state. That's not a motion to dismiss her complaint. It's a motion, well, it's an opposition to her ability to be able to avail herself of that statute. So there are two separate things, but the same principle applies to both. If extraterritorial arguments work in the motion to dismiss, then they should similarly work in their opposition to 47.1's application in this case.
Okay. So it really wouldn't have mattered.
No. And it's not as, I don't know what other lawyers are saying, but it's not as complicated as I'm making it sound. I feel like I'm making it sound more complicated than it is. It's really, really simple. California wants to know where it happened. They don't give a shit about who's a resident and where. Where did the conduct occur? And based off of that, Title VII claims, FEHA claims, get dismissed on extraterritorial grounds. Wait, I don't know if that makes sense or not. I feel like I'm...
Wait, what's M. Russell? I can't... You're in control of the chat, so I can't like click and put anything up.
Oh, let me get back to the chat.
Lyman is presiding over Weinstein's latest case, and guess who funded his brother's movies? Yapar. Yeah.
What was the comment? Which one?
M. Russell, 1239.
M. Russell, 1239. I should not be the one in control of comments ever. I cannot. I can't
do anything with them.
Yeah. I know. I'm usually on Lauren's streams, and she handles all this for me.
You created it, so I don't have control of it.
Yeah. It's not. Oh, there we go. I just had a.
There we go.
Yeah, Judge Lyman is presiding over Weinstein's latest case, and guess who funded his brother's movies? Yep, Harvey.
Yeah, that's true. That's true. I did not. How is that not a conflict of interest? Please tell me.
You'd have to
Because
make.
that's
I remember doing this analysis very early on in this case, because there's the financial tie-ins to the parties in this case and all. I think with Reynolds Company and all. You did a really extensive video about Lyman's tie-ins.
about his stocks and
Yeah, and
because
I think I
there was
remember
already an article in, was it Wall Street Journal? It's been months now, and so much has happened. My brain is just like swollen.
I
But
know.
there was a write-up in, I think it was Wall Street Journal, that there were 13 times that he had not recused himself. Now, he became a judge. He was appointed in 2019.
So
I
he's a
don't know if he
relatively
actually
new judge.
started till 2020, but in 2021, he had already failed to recuse himself in 13 cases he was investigated for, and that was found back then.
Right. I do remember
So who
that.
knows how many it's been since then. But
I
yeah,
think
like
that
this guy so I was calling him a Sony exec because that's what I saw, but he got hired now through Paramount, I guess a couple of months ago. I just found that out today. Somebody had left it in my comments that he's actually with Paramount, and I haven't been able to deep dive it, but Paramount is one of the ones that Lyman has stock in, and it was the one I thought was the most troubling because it's the one that Ryan has a straight up contract with. He, not just Ryan, but his production company, Maximum Effort, they have a first look contract that it's already been renewed once, and it's good till I think December 2026, where and he gets paid like over 10 million. It's an undisclosed amount, but he had a similar one with Tubi, or was it Fubo? Fubo maybe. Which is a much smaller company, and it was probably a whole lot less, but it was named the price. So I know Paramount must be huge. But everything he makes out of his production company, they get first look. And if they want it, they get it. And if they don't, then it passes to someone else. But they paid him a huge amount of money for this privilege. So if he does poorly and nobody wants his things, they're out of a lot of money because they've already paid it. So if he can't deliver, they've lost a huge chunk of money that could affect stock prices. And Lyman owns stock in that. And now this guy, this deposition fight was over this guy who's used to be for Sony and helped Blake with all this stuff, and now he's at Paramount. It's just so messy.
I remember
but this Weinstein oh sorry.
Yeah, no, I remember the law, because I remember I looked into it way back when you did that video, and basically the standard is you have to show that his financial interests are directly affected by the litigation somehow. And then I think that
but wasn't there a degree that included brothers?
Yeah, I remember. Yeah, and I think that
it's in the actual code, but I can't remember. I'm gonna have to go look it all up again.
I'll have to go back and look at what I said, because I had addressed your questions like directly, and I think that it was like I completely forget what I said. It was like months ago. It's like 6 or 7 months ago.
There's so much new information in our brains about this case that the old stuff has slipped away.
Yeah, but there's a world where, it is a conflict of interest and he might need to recuse himself. I don't know what's going on with the Weinstein case, but there was a reason why it wouldn't work in this case. I just don't remember what I said. I'd have to go back and look at it.
I think there wasn't like any one, like it by itself stood alone enough of a connection, but I feel like when you put them all together, it's with his past conduct, it was like, come on, this ain't right. But I think at this point, nobody's going to want that to happen because it would just throw the case back to the beginning. It would be a disaster.
For sure.
But I can't believe he's taken on the Weinstein case. That's crazy.
Kenny Vixen Music says, Omar was trying to bring up a chat and was saying that you always do it. I'm not as well. I'm better than I used to be.
Talking to Lauren. Lauren's here.
Yeah, Lauren does. Yeah, Lauren is. What's up, Lauren? How you doing, young lady? Um,
She needs us to start shrieking. We're putting her to sleep.
oh, we got to start using the word muley. That'll wake her right up. She loves that word.
That mealy word.
Yeah, you're talking about
What's the
eating
other
some
word she
muley
loves? Oh,
pears.
lover. We say lover.
Oh,
You
is
got to
that
make the L and the R very hard. Yeah, she
lover? She don't like that word?
is that the one? I think that's the one she doesn't like.
I've never heard her not looking liking that word. I know she
Oh.
doesn't like many words. I don't know if that's one of them.
Is that one? Did I remember wrong, Lauren? Don't say mealy. Now I'm nauseous in bed.
You know what? I put up
I had a
Halloween
pear earlier,
decorations
but it
today.
wasn't mealy. It was crispy.
Oh God, or a crispy millie cunt. Those are words that Lauren would love to string together.
Lauren's not gonna refuse, or she's not gonna confirm or deny. I thought it was that word. It could be wrong. I could be wrong.
Julio or Hoyo Creative Tennis says so Lyman denying in part and granting in part.
Hey, that's his
Yeah, I
favorite.
think that's what he's gonna do. Oh, it's bigger over here. So Lyman denying it. Yeah, I think that's what he's gonna do for sure. I don't think it's that difficult of a prediction to make, honestly. I was saying that I put up Halloween decorations today, and they're like these huge 7-foot like animatronics, and they're right in
Oh,
front of my window. And I just looked outside and is like, is that a guy staring at me? Oh yeah.
oh, I hate Halloween. I really do.
No, I mean
Walking
I
in the
got
store,
small
and all of a
kids,
sudden,
so
like something, because I'm like not always very aware of my surroundings, and like all of a sudden I walk next to something and it starts talking or moving, and it just
yeah,
really.
those are my favorite. But it's Halloween's really only fun if you have small children. If not, then it's just kind of weird if you're like super into it and like you. I mean, I don't know if it's weird or not. It's just I don't know. Something about grown folks like dressing up as like scary characters, or I don't know, man. I should reserve judgment. I really should. Let me see if I get through the rest of this complaint. I had highlighted a shit ton of stuff. All right, so section 51.9 was intended to fill a gap in FEHA by
Happy
extending
Krispy
harassment
Kreme,
claims.
Lauren. Sorry, go
Krispy
ahead.
Kreme. Oh no, you're
So
good.
she's saying she's going to bed and she's gonna dream of crispy things. So I said happy crispy dreams. Sorry, go ahead.
Oh, I say Krispy Kremes. Is that a thing out in Florida? They got that, or is that a California thing? I don't know. I guess it
I
doesn't
think
matter.
it's all over the states now. It used to be limited, but I think
Yeah,
it's you can get it. You know what? They have it in China. They have it in
really?
Shanghai. Yep. When I lived there, it came to Shanghai, and boy, was I thrilled.
Mm. China's like that is a bucket list destination for me.
Oh yeah, Shanghai is amazing. I love it there.
I was watching YouTube and they have like these shoebox hotel rooms that I thought were weird. Like you like literally it's like just
I think that's
hey,
Japan. Is that Japan? I think it's
you know
Japan.
what it is, Japan. It totally is Japan. Never mind. It's
Yeah.
not in China. It is in Japan. Which by the way, I want to go to Japan too.
Yeah,
Both of those
Japan.
places are on my bucket list. And yeah. Um the Great Wall. I've always wanted to
Mhm.
visit that. I mean, all the touristy things, all the touristy things.
Oh yeah,
I've never been. I really want to go.
yeah.
I'm going
I just
places
got
in
back from
November.
Korea, like a week ago, I think.
Weren't
Yeah.
you also just like in Ireland or
Yeah.
something like that?
Yeah. Yeah. I travel a lot. I always have.
How was the whiskey over there?
In Ireland,
Yeah.
I don't get whiskey. I get Orchard Thieves cider. It is the absolute bomb.
I'd
Best
imagine
thing.
that's probably 1,000 years in the making.
It is so yummy. And
Yeah,
then they have Guinness beer, but it's dark beer and it's strong. It tastes better than the Guinness here.
that's what I heard. I
Yeah,
heard it's not as bitter.
it's not as bitter, but it's still bitter for me.
Sure.
But yeah, the hard cider there is delicious. Our to me the I had some cider in New York. What is it, Angry Orchard or something like that? That was bitter, but theirs is just so sweet and so yummy. But it's a lot stronger than you realize.
Oh,
And you're
yeah,
just
that's
like
dangerous.
sitting there drinking it, and then you get up and walk out, and you're like, "Uh-oh, I'm drunk." That happened to me. But, I
No.
usually, like, have half a beer and, fall asleep. So,
I'm not really a beer guy, man. I've never been a beer
Yeah, I
guy.
don't. No, I'm not crazy about beer.
I've always
I
been
like
like
wine
whiskey and
and
wine
cider.
is cool.
Yeah.
For sure.
And drinks.
All right. Nobody's really interested
Sorry.
in this stuff,
I'm
are they? About these
sorry. I'm so distracting.
no, I mean I'm getting distracted myself. But section, the fee. I feel like we've already addressed these things.
Yeah, it gets to where it repeats the whole thing over again at the end.
But they
But
are
that
talking
John
about
Candy
this.
reminds me later the John Candy thing I want to talk about.
Oh,
Switzerland is one of the most beautiful things I've ever seen. I drove through it from France to Italy, and it was one of the most beautiful things I've ever seen.
I've heard good things about Switzerland. That's another bucket list place.
Yeah, I just drove through. I
do.
didn't stop, and I was very sad about that.
Mm.
Let me write this down because I want to come back to this, but I've interrupted you enough, so I'm going to shut up.
You're good. All right. So this was important. Civil Code 519 prohibits sexual harassment in professional relationships. Prohibits sexual harassment to business relationships outside of the workplace. Lively alleges harassment in the workplace. Therefore, 519 related claims should fail. That's a huge deal. Both FEHA and sections 519 cannot apply. They're talking more about administrative stuff that we've already addressed. And so I'll get to some of these other claims. The complaints fail to state retaliation claims under FEHA or Title VII. So the FEHA stuff doesn't matter. Title VII is still really important, though.
That's
Title
federal.
VII provides, it shall be an unlawful employment practice for an employer to discriminate against any of his employees or applicants for employment because he has opposed any practice made an unlawful employment practice by this subchapter. To establish a prima facie case of retaliation under Title VII, a plaintiff must show that she engaged in a protected activity. The employer was aware of the activity. The employer took a materially adverse employment action against her. And this is a big deal because that literally means, what was that?
Because that didn't happen.
And nor did she allege that it happened. Like nobody threatened her employment. Nobody cut her pay. Nobody denied her advancement. Nobody did anything that was necessarily going to be adverse to her employment.
Right.
And
she got things that she shouldn't even have had access to. Like she got the dailies, she got to edit, she got to change the music. So
there were significant concessions.
Yeah.
Made for her benefit.
She was paid more than anybody.
Right. And then fourth, a causal connection between the alleged adverse employment action that was not pled and the protected activity. And then they talk about 12940H FEHA codes. And then we get into this discussion. Not all adverse employment actions violate Title VII. And it is important to separate significant from trivial harms. Rather, a plaintiff must show the employer's retaliatory actions had a detrimental and substantial effect on the plaintiff's employment, which she did not plead and is not in the undisputed facts whatsoever. And then they give examples of what that even means. Examples of materially adverse changes include termination of employment, a demotion, evidenced by a decrease in wage or salary, a less distinguished title, a material loss of benefits, significantly diminished material responsibilities, other indices unique to a particular situation. But in this case, he had more leeway than anybody else on that set.
Yep.
She was given more benefits than anybody on that set. She was paid higher than anybody on that set. She was given more editorial control than anybody else on the set.
Than the editors and the director.
How could she possibly make this claim? And so under that ground, I could see where a jury would say, you know what? There's no reasonable way I'm going to find. Now, she's obviously claiming smear campaign that was going to affect other stuff, whatever, fine. But here's the crux. Lively does not allege that she was terminated, demoted, deprived of any benefit, et cetera, et cetera. Therefore, the Second Amendment complaint is deficient. Therefore, it should be stricken. That's what they're going to argue. the second amended complaint fails to plausibly plead a causal link between the protected activity and the alleged smear campaign. So here's what I think. So they're honestly, I don't think that they need to go this far, but they do. You're saying that, basically making the argument that she did not plead anything that could be actionable under Title VII, such as all of these things. But let's just pretend that she did. She's failed to plead a causal link between the protected activity and I guess what she's saying is going to be the alleged smear campaign.
Yeah, it's
The law
15 months.
is right, but for causation does not require proof that retaliation was the only cause of the employer's action, but only that the adverse action would not have occurred in the absence of the retaliatory motive. Lively alleges protected activity, complaints of sexual harassment, and a public relations campaign which commenced in early August 2024, at or about the time of the film's August 6, 2024 premiere. The complaint, however, does not link the two, much less plead that the public relations campaign would not have occurred absent a retaliatory motive. Simply put, Lively fails to plead causation, which I would necessarily agree with. But what I also think is she could make an argument that she did plead that. And so,
Even if it's the slightest bit.
right, even if it's like the weakest argument, I think there's still something there where she could plead, like she laid out a series or a chain of events that led from August 2024, the premiere, all the way back to like, I think 2023, if I'm remembering the complaint correctly. But she laid out a series of communications, of events that led to a smear campaign that she could plausibly argue to a jury and therefore probably shouldn't be dismissed at this stage. But I've seen Lyman do stuff that I wouldn't agree with respect to that before. So I could see a world where he would get rid of it because of that. But that's the point. That she didn't plead a direct causal link. Lively's going to say that, yes, I did. And she's going to have an argument to make. There's a counter argument. If it's debatable, then it should stay in. That's kind of my personal test.
Right.
Plaintiff fails to show the requisite temporal proximity, and then we get into these time arguments. Over a year had passed between plaintiff's May 2023 complaints and the August 2024 launch. While courts may infer such a link where the alleged retaliation occurred shortly after a plaintiff engaged in a protected activity, this time lapse exceeds the limit. Where it wasn't really clear is that if there was a definitive, I didn't see in this case law where there was a definitive time where there's a cutoff.
There isn't. And it says that, I think in Uden, that there's not a bright line to define it. But but it's according to the cases, and she's got a mountain of cases there.
Yeah.
There are some like 4 to 6 months was real too long. And look what she did. She did almost all Southern District of New York cases.
Right. And the thing about that is you could cite those cases and you could say, hell, you could say that there's probably cases out there where a couple of weeks was too long. You know, it's all in context. And so if she could somehow establish a contextual claim that 15 months was sufficient to make a causal or temporal connection, then fine, make that argument, but it's going to be hard given the case law, right? And so where there's not a bright line rule, is debatable by default.
So anything that survives this, they could bring this back again with a motion for summary judgment, and the judge could be trier of fact of that, right? So it may survive this, but still not make it to the trial.
Correct. 100%. Yeah. So they're not. They can still bring this up in an MSJ.
Oh, I want to correct that. M. Russell. Someone had told me that, and I posted it before I looked it up personally. I had said in the live that I was going to do that research, but I repeated it before I had done the research and said I was going to look it up. And then I found out later that M. Gottlieb, that was not true. When I actually did the research, it was a different Michael Gottlieb. It wasn't the same one. So, but unfortunately, I said it before I did the research, and it got put out there by a bunch of other people, and pointing back to me. So even though I corrected it on my channel, anyone who went out there and spoke on it as soon as I did, before I corrected it, still is out there repeating it. So that was my mistake. I learned really fast. Don't ever repeat something until you've done your own research on it. But yeah, it's a different Gottlieb. But in New York, from what I understand, Gottlieb is like Smith in other places. It's like a really super common name there. Because he used to work in a firm with a Gottlieb, but totally unrelated.
Yeah,
So,
I hate when that happens. People take like your mistakes
like
and then just start running with them.
the one time I did it without doing my own research, which I try to never ever do. The one time I did it, and then it spread like wildfire before, and like the very next day, I'm like, oh no. And I posted a statement, but it was too late. It had already gone out.
Yeah.
Yeah.
It's
Yeah.
like releasing feathers, a pillow full of feathers off the Empire State Building. They're all gone. Yeah, well, it is what it is, man. What are you gonna do? All right. Getting back to this, the Second Amendment complaint lacks factual allegations to directly establish a retaliatory purpose. I thought this was the weakest part of their motion, but they say that retaliation for Miss Lively exercising her legally protected right to speak up about misconduct on the set. There's two cursory allegations. One, that the public relations plan was embarked in retaliation. That was one. And then Miss Abel, Miss Nathan, Wallace, and Street Relations and others employed or engaged by TAG perpetrated a retaliation scheme against Miss Lively in collusion with the Wayfair parties. This is insufficient to show retaliatory animus or purpose. In fact, the Second Amendment complaint's own allegations show something entirely different, that the alleged smear campaign was not retaliatory, but an effort to defend Baldoni and Wayfair against the anticipated storm of negative publicity from Lively and her team's blistering criticism of Baldoni and his work as the film's director to coincide with the film's release. When you start going through the facts that deep and like making those connections, now we're getting to the point of like factual argument. That's not grounds to dismiss. And so, her claims are weak. I agree. But is it so weak to dismiss the complaints? No, unless you rule like Lyman did with Baldoni's complaint. And then, get rid of that. I don't see how anybody could. I'll never get over, like, what if Ryan Reynolds just believed his wife? How about that? Did you ever think of that?
That was so improper.
Yeah.
Oh my goodness.
If he's going to make a ruling on it based off of that logic, then get rid of all of this. Sure. But under the way that I understand the law, it should remain. And so there's more stuff. Yeah, I'm pretty much to the end of all of these things. We've kind of gone over all these. I don't want to bore everybody going through all of those legal points. But if you could pull up your chart again, we could go through those.
I put the new one there. Do you see it? It's got a 2 after it.
Is it that one? Yeah, it's got like colors and stuff.
Yeah, I don't know if I got all these right because it stretched it into another row and then it went like split it in 2. It looked crazy, so I was trying to fix it.
Yeah,
I might have missed something that you said.
No, and so what I was saying was that if Lyman rules according to the law, count 1 should stay because it wasn't challenged. Count 2 should remain against Wayfarer as an alleged employer, but should be dismissed as to it ends with us because of the non-exhaustion thing. And there was other sub issues about employer stuff that we talked about. Causation doesn't matter. Counts 8 and 9 should stay because they weren't argued in the motion. Those were the contractual stuff, the writer stuff. the defamation counts 12 and 14 should remain because there's arguments that she can make, opinion, privilege stuff. She lied theories. She could still make some argument as to that.
So 12 and 14 would stay in.
It should stay in.
Okay.
Count 15.
So that's wrong.
Yeah, count 15 should stay because it's tethered to defamation. And it does involve outside co-conspirators that she can make some kind of an argument for, and therefore not be, no matter how weak it is. There's a claim that she can make, temporal nexus, all those things that we just talked about. She can still make those claims. What's definitely out, if we just follow the law, counts 3 through 7, 3, 4, 5, 6, and 7, gone because Occam's razor, extraterritorial. There's no provision that allows it to apply to California or to out-of-state conduct. I can't talk. Count 13, for the same reason, extraterritorial. I hate that word so much. Extraterritorial.
Yeah, I always want to say judicial for some reason, because that's what you usually hear, extrajudicial.
Right. 51.9. Also, it doesn't apply to the workplace facts. There's that. False light is not recognized in New York. Counts 12 and 14 should be out. Title VII and FEHA claims, as it pertains to It Ends With Us, should be barred because of non-exhaustion of administrative remedies. They should be gone, dismissed. Everything else should stay in. Everything else being counts 1, 2, 8, 9, 12, and 14, and 15. If you rule how Judge Lyman ruled against Baldoni, I guess only count 1 and counts 8 and 9 should remain.
Let's hope.
Because he should insert his own personal logic that, that's kind of a bit much to rule that conspiracy applies. 15 months between facts. I don't have anything to suggest that conspiracy was even possible. Like, the timeline doesn't fit. She was no longer an employee. That doesn't make sense. Count 15 should be out. Counts 12 and 14 as it relates to defamation, I don't really get it. That should be gone too. Counts 8 and 9, sure. If you want to proceed with that, contract provisions, whatever, fine, keep it. The retaliation stuff, I don't really see that there's facts that are sufficient to suggest retaliation. There's a lot of he said, she said, whatever bullshit, but I don't get it. Count 2 should be out. If he rules the way that he did with Baldoni, then 1, 8, and 9 should be the only things that remain. I'll even give him count 2. Give him count 2 then. Whatever. You think she retaliated or there was a retaliation? Fine. Keep it. 1, 2, 8, and 9. Those could stay. Everything else is out. So I'm giving you 2 separate predictions. One is strictly based off of law. Counts 1, 2, 8, 9, 12, 14, and 15 are in. All of the California employment law related claims are out, 3 through 7. Count 13 should be out. Counts 12 and 14, New York doesn't recognize, out. Title VII and FEHA claims against It Ends With Us are out. That's it. So those are 2 branches that I've offered.
Depending on what mood he's in.
Depending on how he wants to apply the facts,
if he
I
rules
guess.
like he did for Wayfarer, and the other one, if he rules.
If he's consistent, then he's going to trim this down considerably. And if he trims down all of those, then I could see this settling pretty quickly. If the only things that remain is, like, for example, counts 1, 8, and 9, why would she want to go through with that?
Yeah.
Furthermore,
because the most important thing to her is the retaliation. Like, that's all she cares about. All of it.
For sure. For sure. I could see her going forward on counts 2. I don't know, but if it's only counts 1, 8, and 9, why would she want to continue? Settle this thing. If she's no longer entitled to damages under 47.1, why would she want to continue?
And just keep
Like if
paying more.
47.1 is dismissed on extraterritorial grounds, for what? What's in it for her? No good is going to come of this. Settle this thing and be done with it.
Because I think they thought they were going to get so much money back that it was going to cover this lawsuit.
I mean, it was fair to,
but if they don't,
yeah,
if they don't get 47.1, that means they're footing this entire bill.
I guess it was fair to try it. I mean, they were trying to take advantage of a statute that was really, really super protective of conduct that occurs in California. Sure. They found a way to try to make it apply. Good for them. It turns out that this whole argument that we were making, and like we're spinning our wheels for months about 47.1, that Occam's razor, hey, there's no extraterritorial provision, it's not going to work anyway. Well, shit. If that was the whole thing, I mean, we could have just said that way back like in January and never thought of it again.
I tried.
It makes me feel so stupid.
I tried to.
I mean, to be fair, I really try to dismiss it myself. Like, who cares about 47? It doesn't look like. Now, granted, I didn't say because of extraterritorial provisions. I just didn't think it was going to be that big of a deal. But when Ask Two lawyers were like afraid of it, like it really caused me to do like a double and triple take on 47.1, and then it got me freaked out about it.
Yeah, I think they're the ones that hyped it up in the whole community and got everybody freaked out. And it got where I couldn't even stand to listen to them anymore because that's all they ever talked about.
Yeah, I mean, it is a draconian provision for sure.
It is.
But if we're defeating it under extraterritorial reasons, then well, shit. I mean, that was like the easiest thing we could have just, man. Mm-hmm. But you know, I guess the Wayfair, I guess Friedman had something up his sleeve that nobody had thought of. I didn't think of it. I mean, I'm obviously I didn't write this motion. But gosh, that's the simplest way to defeat it, isn't it?
It's so funny. People were laughing and they're like, oh, he wasn't aware of this law. Oh, he didn't know about this law when he chose California law. And I was
he's like, yeah,
he's from California. He is not that dumb.
To be fair, I'm from California and I did not think about that rule. I mean, I'm not paid to think about it either. So there's that. But it's so funny. Yeah, Friedman doesn't know what he's doing. He's in all over his head. He didn't consider 47. So yeah, I knew about 47.1 and extraterritorial, bitch. How about that? So, did you consider that?
He's like, I just not saying anything till the time runs out.
But he did say, look, I'm not going to file a motion to get them to correct their deficiencies. They don't know what they're doing.
He said that. And
he did say that.
He meant it. He was not fooling. That's why like a lot of people have gotten so critical of them. And I'm like, these are really good attorneys. They are not this dumb. Just they're not out there like spilling their guts all over, letting everybody know what their strategy is and fighting over every little thing. There's a reason they're not in there fighting for stuff all the time like Blake's team is. They are very secure in whatever they've got in their bag. I'll tell you that much. So I'm not criticizing them. I think they've got all the ammunition they need. And I think they're not the slightest bit concerned about anything.
Yeah. I mean, they've had a game plan. I mean, they were confident enough to not give a shit about Baldoni's cross complaint.
Mm-hmm.
That had me shook. I'll tell you what.
Won't even file. They're like, that's okay.
Yeah. I mean, the dismissal of the cross complaint had me shook for like a good week until I just started reconsidering, you know?
And then I thought, well, you know what? If they're not doing anything about it, there's a reason, because they're not lazy, stupid lawyers. They know what they're doing.
They were going to find, you know, they had their arguments that they knew they had statutory arguments that they could rely upon. Statutory arguments are the strongest, you know? It means that you have to follow them. There's no discretion in that. And when you have those arguments, and it makes all the sense in the world, why didn't they file a 12B6? Why didn't they do this? Well, they were waiting for the 300 days to expire so they could get rid, so they can't fix it, you know?
Note to everyone, do not underestimate these people.
Mm-hmm.
And they've also got whatever they're planning to do about Van Zandt. They are not letting that go. I've had so many people taunt me on X. Well, nothing happened, did it? You know, they're not doing anything. They are still, look, they got the deposition tomorrow.
Yeah.
Okay. They've been getting their stuff together. We have no idea what they've got planned, but they might want to do something that's completely out of Lyman's court for that. They
I'll
might
tell
want
you
to
what.
file criminal charge. If I were Jennifer Abel, you would not be able to stop me filing criminal charges for what happened to her.
There was
So
there was something that I had said a couple of months ago, a few months
yes,
ago.
there's I know that's French. So, but I don't speak French. I mean, I took like a semester of it in 8th grade. So I know I'm going to slaughter it. Machante Chatone. I don't know. I always end up with a little bit of a Spanish accent because I learned more Spanish. But yeah, I love her. I love her comments. She's so smart.
Mashante, I mean, I'm gonna, if you butchered it, I'm gonna butcher Mashante. You know what? It says Mashante Chatoni. Oh my God, I sound like cowboy. Mashante Chatone or
Is that the
Chatouan.
wine you were drinking that you let go bad? It sounds like a lovely French wine, doesn't it? But she's so
a nice Chianti. She says Van Zandt is still central to the counterclaims against Stephanie Jones. It is in that amended complaint. Yeah.
Mm-hmm.
I'll tell you what. This is what I said a few months ago, 3 or 4 months ago. I said that Blake Lively and her legal team is litigating like a bunch of bitches, straight up. Like they're the whiniest.
But it's so true.
They're like trying to snitch on every little thing that Friedman does, and Friedman's legal team is sitting there. They're quiet. We're not filing 12B6s because we don't care.
Yeah.
We're not going to file an amended complaint because we don't care. We're not going to file. We're not going to tell on them. We're going to do that. We just don't care.
Yeah.
Because
and then
watch.
when Gottlieb and Ezra file anything, they always sound hysterical.
Mm-hmm. They do. Like they sound like just bunch of tattletales.
Yeah, they sound like mealy.
Like mealy, crispy cunts. That's what they sound like. I'm not sure if that's possible. Mealy and crispy. That's gross. Ew.
Yeah, yeah. Well, that's like Blake with her multitudes. She's mealy and crispy.
Oh, yeah. Sometimes this is a lesson for lawyers. You don't always have to file every stupid thing that you could possibly file.
Yeah.
Sometimes it's a sign of weakness to do that. You know?
It is. And I think their silence is part of what's making Ezra and Gottlieb so hysterical.
Mm-hmm.
They don't know what's coming.
Yeah. No, it is, man. Sometimes when you have a winning case and you know it, like one of the most valuable lessons I learned as a young attorney was when you're winning, just learn how to shut the fuck up. Like if you know you got it won, if you know you have it won, just shut up, man. Just be quiet. Don't say anything else. It's just not like the movies. Just let if your opponent is screwing up, let them. If the judge is going to rule in your favor, then let the judge rule. But do not just say extra stuff for the sake of saying it. Nobody thinks that you're that eloquent. You're not Matthew McConaughey in A Time to Kill. You know, you're not in the movies right now. And so, look, sometimes I think that I don't know. I just feel like they have been litigating a certain way for months now, and now it's all starting to come to pass. We're approaching October. Trial is like 5 months away. There's depositions and things happening, and now as the entire book is starting to unfurl, you're starting to realize that all of your instinct about the weakness of Blake Lively's complaint against Baldoni and the Wayfarer parties, your instinct was correct. And next time, be more trusting of your instincts as opposed to worrying about all of these ancillary rulings that Judge Lyman is making because of the Lively's legal team filing all of these stupid red herring type motions that are getting granted and talking yourself into the fact that you think they're winning because they're winning these motions that don't matter.
Yeah, that's a good point. Because I do get so worked up of the unfairness that it looks, and the way it looks. Because to me, what bothers me the most is that after each of these things happen, then the mainstream media puts a story out there, and then the people who don't come to social media and hear all of this, they just hear those little bits of things.
Yeah.
And they think, do you know someone in my family I was talking to, because I don't talk about my YouTube stuff um around people that I know. And my parents know, but like not even my
Yeah.
sisters do this. But there people like thought that this case was over. Remember when they did the victory lap over
Yep. Yep. I
the
remember.
motion to be dismissed? My family thought the case was over on that day and that Blake won, because that's how
Yeah.
badly misrepresented it is in mainstream media, and none of them are really into social media. So yeah,
Right.
that's what people think. They thought, "Oh, I thought that was over a long time ago." So that's what bothers me. Like when I get mad, that's why I get so mad, because that's what gets released in People magazine and Us Weekly, and then people hear that and run with it. And to me, that's a potential to tainting a jury pool. So that's one of the reasons I get worked up. And I just hate to see injustice and unfairness too. It just makes me furious.
I didn't view
But
it that. I mean, I know she was doing her victory lap, but of course she would, because she had been getting a lot of shit about it. You know,
Mhm.
her speech at that whatever that award was that she was like Woman of the Year or
Oh,
something, and then she was like
the
trying
one
to,
that Ryan bought, the Times 100.
yeah, time whatever that was, and she got a lot of backlash for that, and this was like some victory for her. So of course she was going to play it up, but it was a red herring. It's like, who cares? You won that. We're not even in the regular season yet. You won a preseason game. Who cares? Good for you. Yay.
Yeah,
You
they're
know?
I'm gonna call her just Mashante. Keep
Mashante.
making it easier. Mashante. Yes, that was the other victory lap she did, that she won thanks to 47.1, and thanked all the amicus brief people, even though he clearly said he did not even read those briefs. But it
I
didn't
did not
stop
even
People
I didn't
magazine from putting it out there.
Blake said that she won thanks to 47.1 on Instagram and
Yep,
happened to have a
that's what was in the
Vogue
mainstream.
photo shoot and
Yep.
like 20 amicus briefs, even though nobody knew Lyman was ruling then. Well, he didn't rule on 47.1. He's like, okay, that's not, thanks for the briefs. What do you want me to do with these? He didn't make a
But ask,
ruling on 47.1.
people out there who don't watch YouTube and TikTok and know better.
Oh, for sure. No, I believe that. Yeah.
Yeah, that's what they were told.
Um,
But I want to bring up this John Candy thing too, before I
sure.
wrote it down, because I know. Did you see that?
No, I don't even know what you're talking about with John Candy, but I love John
Okay,
Candy.
so yeah. So you know that Ryan is a producer, one of many on the movie, and he's doing some kind of tour, as if he's like star director. It's all about him. He's doing this tour called an evening with Ryan Reynolds. And he as okay, remember the mixed drinks that were in It Ends With Us? And
I've
there was
never
like a
watched that
menu.
movie.
No, it's not in the movie. It was
Oh, okay.
in the promotional things, at like the premiere. And there was
Okay.
a list of the mixed drinks, and there was like Rile You Wait and all that. And it's one of the big things that um Blake ended up so criticized over, because she was hawking her alcohol at this premiere, and it was a movie about domestic violence, and a lot of women who are victims of that, it happens once their husband gets drunk or whatever. So I mean, the percentage is astounding when you
Yeah.
add alcohol to the mix. So everybody knows that, and you should know that that's a topic to avoid when you're talking about this, just because of that situation. So the exact same setup, it's a table with the exact same sort of menu of drinks, with this time it's Ryan's Aviation Gin, and it's all these John Candy themed drinks
Oh, wait a
with,
minute. He makes
and it says,
aviation,
no, he doesn't make it. He
but
was
he's
the
like his name is on
spokesperson
it.
for it and a high stockholder in it. And then he ended up selling the company. And that's one of the
Hmm.
companies that that he made a lot of money off of, but he's still their spokesperson. He's still related to it somehow. But
Gotcha.
he's hawking it. Okay. And if you know anything about John Candy, you know that one of the reasons that he died prematurely is because of alcohol and other, what's the word?
I mean, he weighed like 400 pounds.
Right. But he struggled with alcohol.
Yeah.
So while he's out there promoting this movie about the life of John Candy, and it's so sad that he died so young. And one of I saw this on Ken's on Instagram. She made a video about it, and she said that in the autopsy that it ruled alcohol and other substances as contributing factors to his premature death. And so Ryan sees fit to make up a drink list, and it looks just like what it was for It Ends With Us, the premiere. And it's all these John Candy themed drinks, and it's just in such poor taste.
What a dick. Like, why would you do that?
Why would you do that? It's like he's learned, that's what Ken was saying. He's learned absolutely nothing.
I've determined, look, I didn't know anything about Ryan Reynolds before any of this. And I still I've never met the guy, but he's a piece of shit.
Yeah.
Like he's just not a likable human being.
No. The more you find out, and what's interesting is that when you go back, see, I lived outside of the States for over a decade. And I've never been one to like be into the celebrity culture.
Yeah, me neither.
So I never saw like all these little video clips of them, on late night shows or promoting things. I never saw those before, but these people have been telling on themselves all along. Ryan, worst of all, like he'll say these things about himself that are absolutely horrible. And everybody's like, oh, his self-deprecating humor. No, he's been telling you the truth the entire time, but you weren't listening.
Yeah. Because
now that they're all being played, it's like he's absolutely not even trying to hide who he is. Yeah.
This is a big shitty piece of shit.
A mealy piece.
A mealy, crispy, big shitty piece of shit. By the way, John Candy, I put John Candy like in the same categories like Robin Williams.
Yeah.
He's like influential, magical actors that just have a charisma that takes over the movie,
Yes. That just made you laugh.
Yeah. Like, what's your favorite John Candy movie? What would you say is your favorite role that he played?
I haven't seen him in decades, and I was really, really young.
Yeah.
So to be honest, I probably couldn't tell you. I would need to.
Well, there was like Uncle Buck. There was Uncle Buck. There was Spaceballs. If you haven't watched Spaceballs, just watch it. Just watch it.
Spaceballs. But I think Uncle Buck is one that I've seen.
You must have seen that. Yeah, that's been on TV like for, I don't know, that's like the go-to. It's always on TV somewhere, Uncle Buck.
Now I need to go watch a bunch.
I know. And then there's a Planes, Trains,
I know what I liked him in. Splash, the mermaid movie.
Of course, that's the one that I never saw because it's about mermaids. Well, I watched a movie called Splash.
Yeah.
Cool Runnings is a good one. Yeah, Rescuers Down. I never saw Rescuers. But Spaceballs.
Yes. And Cool Runnings. Yes. Okay. Now you're naming stuff I know. But I never saw Spaceballs. I don't even know what that is.
It's a spoof. It was made in 1987. It's a spoof on Star Wars. And he plays like, I guess, the character that you would imagine Chewbacca being. He was like a dog in the movie. It's stupid. It's completely stupid. It's a Mel Brooks film.
But I love stupid stuff.
Yeah, but it'll make you laugh, and it's not for everybody. It's definitely dated. It's very 80s. It's very 80s, but it's hilarious. You got to watch it. Planes, Trains, and Automobiles is probably his best acting performance, like throughout his entire career. He did a rom-com once. I forgot what it was called. But anyway, yeah, Planes, Trains, and Automobiles.
I feel like I need to go and see where I can find all these and
on freaking Amazon Prime or like Netflix. I'm sure has some.
Yeah, I've got all the streaming.
Spaceballs. Yeah,
Spaceballs. Let me write it down.
Definitely Spaceballs. I show my kids Spaceballs. They don't care.
Spaceballs.
I made my wife watch Spaceballs, and she wasn't down. She was not.
Yeah, some movies are more for guys.
Yeah, she also didn't like Planes, Trains, and Automobiles. I mean, she was born in '85, but that should.
Oh, so she's not gonna dig.
I mean, I was born in '80s. We're not. She's not that younger than me. She just doesn't like the older films. She doesn't appreciate older cinema. What can I say? I'm just saying.
I just watched an older movie, and I was like, man, this is cheesy. It was I loved the second half of it, but the first half was really hard to get through. Because Robert Redford died, so I was watching Robert Redford movies.
Oh,
and it was Michelle Pfeiffer and him. Oh my goodness, I cried so hard at the end. It just completely took me by surprise. They were journalists, and they end up getting married. But the beginning is like so cringe. I almost didn't get personal. Through it. Yes, that's it.
I've never watched it.
Okay. If you can struggle through the first half, the second half is really good.
You know, Robert Redford.
It's got that old style, and it's kind of cringe. I'm not gonna lie.
Like 70s style.
No, I think
96 romance. It was a rom-com or drama. Oh God, this is not a movie for me. It is not.
So that's like Spaceballs for your wife.
Exactly. So again, maybe I'll make her watch this one, and it'll be more palatable.
It's funny because I have my sign in on Netflix, my sign in on Hulu, my sign in on Prime, and no, not Prime. And then my husband's there, and they couldn't be more different. Like if I turn it on and it's on his, I can't get out of it fast enough. And I'm sure he feels the same. Oh my gosh, Out of Africa. Yes. Robert Redford and Meryl Streep. That's when I fell in love with the two of them. The first movie.
I don't watch these movies. I'm exactly like you. I can't watch my wife's channel. I was like, you know what? No. Get back on mine right away. What is this shit? It's all about animals and like romance and stuff. And Redondo Beach says, I love that Blake made Ken's with the subpoena. What's Ken's? Made Ken's.
Oh, she made Ken's. Ken's was just a tiny little I subscribed to her already on Instagram, but she was just this tiny little Instagram account. And I think was she the one? She only had one sub on YouTube. She didn't really do much on there. And when she got subpoenaed, she like got 1,000 subs on the first day. She really did. She made her famous. But she's got that little blue, like teal, sequined, glittery spatula that she talks into like a microphone. And it's bedazzled spatula. It's so cute.
I think I heard about her just being like one of the smaller content creators.
Yeah, she was tiny, and now she's got a really good following. I'm so glad because she's hilarious.
Good for her. Good for her.
Ariana, the rom-com that's. Let me write these down.
Delirious is the rom-com.
Is that the John Candy rom-com? Somebody said there was one.
Is that the John Candy? I'll tell you if it is right now. Delirious. John Candy. He was like wait a minute. Who was like the love interest? And he had like this racist mom. That's what I remember. And they had like a date on at Old Comiskey. 1991. Yeah, that's probably it. It might not be, but it is. Stripes? It might be.
I think I saw Stripes. Does that have Bill Murray in it too?
Yes. Stripes is it has Bill Murray.
Yeah, I've seen that one too.
Oh, I gotta like make another YouTube channel where I talk about movies. It's way more
Yeah.
fun than talking about this shit. You know?
I'm making a kids YouTube.
Really?
Yeah.
Oh,
Yeah.
my daughters are all into YouTube. They would love it, I'm sure. They're all into like
It's
Sprunkies
how
and
old are
stuff.
they? This is gonna be like this is it's learning to read series, so they're I think that your daughters might be a little too old
They're 5 and
for it.
6.
Oh, okay. The 5
Yeah.
it might be okay. But it might be just a little bit beneath them because it's like learning the alphabet and stuff. Yeah, I used to be a director of international preschool. I
Did you
designed
really?
yeah, I designed the building
Oh,
inside
my camera's dead. I
and
have
the
to
curriculum.
I gotta here. No, I will be an avatar as well. My camera's dead. I forgot to connect it to like the battery. Nah, it's all right.
Oh, is that what?
Yeah. Um
Yeah, so I'm
y-
working on that. So
yeah,
you're interested in doing Murdoch stuff, huh?
yeah, we got to do a Murdaugh thing. I had no idea that the appeal was going on, but
Yeah, they're in the middle of the appeal right now. So he filed the appeal and then it was hilarious. They were so stomping mad because it got they got so many um extensions on it that it was like a year in the process before the state responded.
oh
So the
boy.
state responded and then they've already responded to the state's response. So I'm a little bit behind. But yeah, it's in the middle of the appeals right now.
I'll
Did you
say
keep up
because
with the whole thing?
no, I covered it on YouTube. It was like one of the
Did
first things I
you?
did on YouTube. Yeah.
That
Yeah.
yeah, that was it wasn't the first thing I did. I used my YouTube for something else before and then what I deleted all that though. Now I just have from the Murdaugh. Yeah, I got obsessed with that. And then I did a deep dive into the family, like the
Mm-hmm.
history. I
Yeah.
went all the way back as far as I could find in their ancestry. And I got old newspapers and like told the story of them all. And
Well,
yeah,
we
it
should
was
definitely do something about the appeal. For sure. Because I heard that you had covered the Murdaugh case.
Mhm.
It was like, yeah, that would be perfect. But I had no idea that the appeal thing was going on. I've just been so out
Oh
of the
yeah.
loop with all that stuff. But I was definitely, I mean, that judge was like the best judge, you
The
know?
best judge ever.
I
I
know.
worship that man. Do you know I went to some of the I didn't go to the actual murder trial, but I went to some of the hearings and I did
Oh,
some
did you
tours.
really?
I did. And I got to
Wow.
rise for Judge Newman right before he retired. It's like
Wow,
the
it's a
one
shame
of
he's
the coolest
retired, right?
things. Yeah, he does mediation now. He moved to Atlanta and he does mediation for what's that
Good
called?
for him.
Yeah. But that is the most honest, righteous judge I've ever laid eyes on in my entire life. And he's
Man, it's hard
so
to find fault with him,
patient.
you know?
Yeah, because normally they get that God complex and they're just grouchy and
Yeah.
they know it all. And this man is like Dick Harpootlian is so appropriately named. The way he spoke to that judge on occasion, you know,
Oh, I
and
miss that guy, sort of. Not really, but you know what I mean.
oh, I can't stand. Oh, he's got a book coming out. He's got a
I
book
bet
coming
he
out.
does. Of
And
course he did. Of
you know what,
course
I'm
he has
so
a book.
mean. I cannot stand that man. I've seen him in person twice. And
Yeah.
he's not much taller than me. He's a really small guy. But
He seems like the casting couch type of guy, you know what I mean? Like the kind of guy that would take
oh,
advantage of his position.
absolutely.
You know what I mean?
That guy is pure, slimy, grimy. You know there are a million skeletons in that mess. You can feel the ick when you're in the same
Yeah.
room with
Oh, I know the type. I
and
definitely know
yeah,
the type.
just he was oh, nope, nope. I'm not gonna say too much. But yeah, I can't stand him. I can't stand him. And so he made this I always heard about him being something with this Pee Wee Gaskins, this uh serial killer in South Carolina, like the legendary serial killer, and that he um had something to do with this. So I'm like, I thought he was the guy who prosecuted him for like discovered him being a serial killer. So when they're always naming him with Pee Wee Gaskins, I'm like, oh, he must have had a big part in the takedown. Here's what he did. Pee Wee Gaskins was already in prison. Okay. And somehow he gets C4 smuggled into the prison, and he blows up, and he kills a guy on death row in prison. And that's what Dick prosecuted him for. I'm like, how hard was that? How hard was that? The guy
C4?
was, yeah, like, how do you get that? Yeah, C4. So I'm like, how hard was that to track down? The guy was already in prison. And
Yeah.
how hard is it to trace who got C4? And now he's, so he didn't do anything, like, they're always tying this guy's name like he did something amazing. That wasn't hard at all. And then he prosecutes the guy. I'm like, that's like fishing in a barrel and bragging about the big fish you caught.
I'll
This
tell you
guy
what,
was
and
in prison already. And so he's out there bragging about his book, and I couldn't help it. I saw it on X, and I'm like, what the big mystery would be is just to discover how somebody got C4 to him in a prison.
yeah.
He never responded. Because
You
I'm
know
like,
what?
nobody needs to read your book because you didn't do anything amazing. All right, but how about find out how the C4 got in the prison?
Whenever prosecutors like brag about their record, about like all these amazing victories they've had in court, it's just like the stupidest, it's like the slimiest thing you brag about.
It is so slimy. And I'm telling you, like, being in his presence, you literally feel the slime.
Yeah,
I'm
I believe
really
it.
good at judging character somehow,
It
especially
oozes off of him,
it oozes, and it's worse like in person. I was within like 4 feet of the man, and I felt like I needed a shower. It was so gross.
I believe that, but I'll tell you what, there was one time where I did feel some kind of sympathy towards the man. It was when Murdoch took the stand. And he did, the whole thing when he was like testifying, and he shouldn't have had no business testifying, and he wanted to because whatever. It's like, gosh, man, what is Harpoolian thing? There's no way that guy wanted him to testify. They probably had like the biggest argument
They
over
begged
it.
him. Yeah, he stood up and said, "It hurts my feelings that he's testifying." Oh, thank you, John Dallas. He brought the book that I narrated the Audible version of a book written by one of the jurors from the trial.
Oh, really?
Yeah, I did.
So you're like a legit like Audible like voiceover.
Yeah,
person.
I have. Yeah, just the one book I've done. I should do
So
more.
there's a reason why you sound like AI.
I used to get accused. I used to cry about it. I did. I used to cry.
Really? Why?
Yeah, because it was people would just they would come and leave like nasty comments like, "This is AI," and just like downvote and just and then I started going live, and finally, but I still get it every now and then.
Nah,
Yeah,
I think everybody knows. Well, I mean, not everybody, but I think most people understand that you're not AI at this point.
Yeah, but it's funny. I had another one just this week. It's been a while, but
Really?
yeah.
I've never been accused of AI. It's probably because my voice is weird. But if I got accused of being AI, I think I would take it as a compliment. I think I would. I don't know.
Yeah, well, people weren't being nice about it. They're like,
Oh,
yeah. They were like, "Oh, it's a crap channel. It's just AI generated nonsense,"
it is not AI generated. It specifically is not. Ariana Boykins with the 5 says, only the lonely. That was the one with Ali Sheedy. That's the one I was thinking about. It was not Delirious. It was Only the Lonely.
Okay, only
John
I
Candy
might have
rom-com.
seen that. I might have seen.
Yeah. The only thing I didn't like about that is like John Candy with Ali Sheedy doesn't make any sense.
No.
It didn't make sense back then. I think that was like 91, 92 or so.
She was on
You're talking about Ali Sheedy in her prime. Like she was just coming off of like Breakfast Club or whatever. She still looked like that, And
oh.
but yeah, he had this mom who was like great in the movie. She like played like this Italian racist. She is not from Sicily. She does not have pure Italian blood, and so therefore,
Oh, not
it
good
was one
enough.
of those. Yeah, but I'll tell you what, Only the Lonely. That is a movie that seems like is right up your alley. I think that you will like that one.
Okay, I'll try that one tonight. I'll try
Yeah.
that one first because that sounds like more my speed.
Definitely more your speed than Spaceballs. I'll tell you that. Although Spaceballs is hilarious. But I'll
Yeah,
tell you
voice
what,
tone.
folks.
Irma, voice tone has a lot to do with breathing. It really does. And it took me a long time because I get nervous. Plus, I have allergies, which causes like an asthma sort of. So sometimes you can hear my breathing is like kind of gaspy when I'm having
Yeah.
that issue. Sometimes I'll do a puff before one of those what are those called? Inhaler. I'll do an inhaler before I record so that it doesn't do that. So like right now I'm okay. So my breaths aren't so deep, but sometimes they sound kind of crazy because the constricted airways with allergies. But yeah, if you don't want to go into like that one thing I can't stand, vocal fry. Oh my goodness.
Oh
I
God,
can't
vocal fry.
stand
Yeah.
that. Oh my gosh. But yeah, it's all about keeping enough breath in your lungs.
You know what I
So
learned? The one thing that I learned about that was that your voice will sound much more powerful and project a lot more if you speak from your stomach. Like if the source
mhm,
of sound comes from your guts, as opposed to like higher up in like your
your
throat. Like
nose.
your voice will project more and it will sound stronger and more clear, and it'll just be more pleasant on the ear. That's the only
Mhm,
thing that's ever stuck with me, and it's worked for me
mhm.
for whatever that's worth. Your
Yeah,
diaphragm, exactly,
yeah,
Irma.
yeah. Yeah, I used to go higher to counteract it, but that doesn't do it, and then it strains your throat. So I learned to go, like, deeper, but I had to listen to a bunch of YouTube videos and work on it.
All
So
right, folks, I really got to go now. It's been an
all
hour
right,
and
thank
46
you.
minutes.
Oh my goodness.
I mean, for
Well,
the
it was
last
good to
30
have you
minutes,
back.
we have not been talking about the Lively case, which has sort of been refreshing, but I'm sure I'm going to get
Yeah.
negative comments about it. I'm certain.
Yeah, I'll every now and then I'll get a, "Why is it so long?
I
Why
don't
can't
know.
you
How
do
come you were
shorter
talking
videos?"
about
I'm
all
like,
this stupid stuff?
"What?
It's like,
Watch it
whatever.
in segments then. If it's too long, watch it in segments. Sorry."
Yeah. I
We
mean,
need
I
to
didn't,
catch up with Omar. It's been a long time.
it is a live show. I know I haven't been on the case for a couple of months now. I
Mhm.
think the last time I was live on Lively was when I was with you. We were live together.
Yeah.
And then I only had like 30 minutes, and so we had to like rush through it.
Oh, yeah, that was really fast. So
Yeah.
if you need the appeal documents from the Murdoch case, let me know and I'll email them to you.
Yeah, send them to me, and then we'll figure something out
'Cause,
like this week,
yeah,
and
if you're not
we'll break
familiar
them
with
down.
the South Carolina, everything they're amazing. Everything is free,
Oh,
on
good.
their docket. Like, some states are not like that, but theirs is really good.
Oh,
So,
I'm aware. I'm aware
but if
that a lot of states are not free for
yeah.
sure.
So if you need, the appeals the appeal briefs, I can send them to you.
Yeah, just send them to me, and then we'll do something about the
Okay.
Murdoch appeal this week.
All all right. So thanks everyone. Sorry I can't control the chat, but thank you for all of your very, very nice super chats and all your wonderful, beautiful comments. And thank you to all the mods out there. And have a great night.
You know what? I got to make more mods. I don't have enough mods. Like I should make some more. On that note,
Yeah,
I think
Christina
that
is
it's.
amazing. She's
Oh
always
yeah,
here
I can
for me.
see it. She is your mod.
Yeah. I think she mods for quite a few people.
You got a
And I'm
lot of
so
people in
awful.
here.
Like I never tell anybody when I'm going. I always forget. Like, some
I'm the
people have a
same way.
strict schedule, they go live every Monday at 7 or,
Yeah.
I always wanted to be that person, but I'm not that person.
Well, not yet anyway. Maybe someday. Maybe someday you'll become.
Oh, yeah. Don't F with Justice she would probably be a great mod. I should mod
Oh,
her.
is she in here? I don't
Yeah,
see her in my
she's so smart too.
let's see.
She's
I'm
got
gonna
some real
mod somebody. Who should I mod? You know what? I'm not gonna make any hasty decisions. But I'll tell you what. I'll tell you what.
yeah,
I'm gonna add some more mods on my next stream. How about that? If you
yeah,
want a mod for me, just hit me up an email, and then we will see.
yeah. Then he'll interview you, 3 interviews, and
Yeah,
then
just gonna
you gotta
know
pass
that
the
you're like a
Warren
real
test.
person. Yeah, the Warren test.
The Lauren,
bun-
you gotta pass the Lauren test, and don't
the
be
Lauren
mealy.
test.
Don't be
No,
mealy
or crispy.
or moist.
All right, folks. That's all I got for
All
you
right.
today. I
All
will.
right.
I hope you all have a wonderful Monday. We will see you all next
All
time.
right.
Bye bye.
Good night. Thanks.